Welcome back to the channel, everybody. Thank you so much for joining me and allowing me to continue to be your daily advocate. If you're new here or you're not subscribed for any reason, please do me a huge favor and hit the subscribe button. Thank you to all of you who have been watching and following me for so long. It truly means a lot, and I'm glad that I can be this person.
Ripple loses patience and wants court to sanction SEC. Whoa, how about that? And in fact, I'll just show you this here in the intro of the video. Look at this tweet from attorney Jeremy Hogan, and this is regarding the most recent legal filing from Ripple on an issue having to do with the Mets supplemental document. If you're not familiar with what that is, don't worry, I'll set the table for you. But look what attorney Jeremy Hogan had to say. He highlighted a few key words from Ripple: gamesmanship, prejudice, sanctions, and then he wrote, "I would say the gloves have come off." Yes, I agree with Jeremy, and you'll see why. This is one of the more strongly worded papers I've ever seen. It's certainly a shift in tone compared to certain other legal filings. So I want to highlight that. And also, there's an organization called the Blockchain Association, which is supposed to be the unified voice for all in crypto. At least that's how they position themselves and pushing for proper crypto-related regulation. Well, they just released a paper having specifically to do with the SEC's, let's just say, unsuccessful and inappropriate attempts at regulating the space. And this paper that they wrote, rather lengthy, didn't mention Ripple or XRP at all. So I'm going to share with you a few comments from the community on that, including something from attorney John Dean. But before going any further, I do want to be clear, I do not have a legal or financial background of any kind. I am not offering legal or financial advice, and you definitely should not buy or sell anything because of anything that I say or write. I'm just an enthusiast who enjoys making YouTube videos about crypto-related topics, but just as a hobby and just for fun. Credit to attorney James Filan, who shared this document all up on the Twitters. I'm going to share with you just some specifics from this, and then I'm going to jump into opinions from 3 different attorneys within the XRP community on this topic. So again, this was filed by Ripple's attorneys. Now, what is this about? Well, here you can see James Filan wrote, Ripple, Chris Larson, and Brad Garlinghouse have filed a letter in further support of their motion to strike the SEC's late-filed Mets supplemental expert report. So this has to do with a report that the SEC paid Dr. Metz to create. And the report, which is over 100 pages, came to the conclusion that XRP price action follows developments surrounding Ripple, which of course would make it look like more of a security of truth. Now, of course, that's not true. It can be provably shown that XRP just follows the broader moves of the crypto market, specifically led by Bitcoin. So it's methodologically flawed. And this guy got paid $600 an hour to put this damn thing together. Taxpayer funds, think about that, $600 an hour. Ripple hired their own professionals and said, no, your methodology was incorrect. And after they cited the reasons that the methodology was incorrect, Dr. Metz came back and said, no, I've got a response to that. But that was filed too late, and that's where we pick up here. The SEC wants this to be considered within the case, and effectively Ripple's attorneys are saying, no, it's outside of the timeline, and then they cited additional reasons that it would not be reasonable to have this supplemental information be considered. And specifically, they highlighted 4, so I want to kind of breeze through these, and I want to get into the opinions from the attorneys. Number 1, Dr. Metz's failure to anticipate a criticism of his inadequate opening report did not implicitly invite the SEC to file an untimely reply report. No kidding. Logic be damned, though, right? Number 2, the importance of Dr. Metz's report only serves to underscore the inexcusable quality of its delayed submission. I like that one right there. We'll see how the judge responds to that, but I personally, I was like, the importance of Dr. Metz's report only serves to underscore the inexcusable quality of its delayed submission. Yes, it's so important that he was so irresponsible to not take care of this in a timely manner. Number 3, defendants, and this is my favorite one out of the 4, I think. Number 3, defendants would face great prejudice if this litigation, which has placed their business in limbo, is further delayed by reopening discovery. defendants would need to marshal additional resources to address Dr. Metz's newly filed reply report when the parties ought instead to be focused on summary judgment practice, and the SEC would again be rewarded by further delaying resolution of the ultimate issues in this case. So it's clear to what they're saying here. If the judge grants this, you're basically reopening discovery, and then this would require Ripple to pay to have their experts come back in and have a reply issued as a result of that. Except for there seems to be some sort of precedent for perhaps the plaintiff having to pay for this if it's their action, or in this case inaction, that resulted in this set of circumstances. It might be the case that they have to pay for this. And so Ripple's attorneys, they actually cite a specific case that's relevant to this, and then they write the SEC's citation to, and then they name the case, is inapposite. The court there determined that the expert's supplemental report was a proper rule, 26E, correction to a mistake in the expert's earlier calculations. Acknowledging that even this mistake, although unintentional, caused prejudice to the defendant, the court required plaintiff to bear the cost of the continued depositions, including defendant's reasonable attorney's fees incurred in preparing for and taking the additional depositions. There you go, Ripple arguing, hey, the case that was cited previously by the SEC, which Ripple's attorneys brought up here, says, no, that's a bad reading of that, and in fact, you might, if you're going to apply the precedent, looks like perhaps the SEC should be paying for Ripple's attorney fees, and perhaps even for the additional development having to do with this prolonged discovery period. Number 4, a continuance would reward the SEC for its gamesmanship and further prejudice defendants. The SEC has already asked the court for numerous extensions in this case that defendants have vigorously opposed. So pause, you can see the tone in this is a bit different than what we're used to. I'm not complaining either. I personally find it a little scrumptious there. I don't mind that. I'm happy to see this. And then they continue. The SEC's decision to wait until after the very last deposition scheduled in this case to file Dr. Metz's new reply report necessitates sanctions. Rule 37 sanctions specifically serve to several important purposes, such as ensuring that a party will not benefit from its own failure to comply and serving as a general deterrent effect on the case at hand and on other litigation. So there you go. The SEC failing to comply, their own incompetence right here. And so Ripple's arguing their incompetence should not result in Ripple, the company, being prejudiced. It sounds reasonable on the surface. So I you know me, I think Ripple should win on this, but are they? Well, that's the question. Take a look at this. XRP Crypto Wolf responded to Jeremy Hogan on Twitter and wrote, "Ripple should have taken the gloves off from the start. SEC plays dirty, but the XRP army has been digging up all the dirt." Ain't that the truth? XRP Crypto. I won't heart that one. Attorney Jeremy Hogan responded to that and wrote, "I tend to agree with you. I think it was a mistake to agree that earlier extension because that's one less instance of an opposed request that Ripple can point to. After that one, Ripple told its lawyers, stop playing nice." And you may recall that there was an extension that Ripple didn't push back on, and I talked about it. I said, well, maybe it really is just the case that Ripple's picking and choosing their battles. It's not a very long extension, but here Jeremy Hogan's pointing out, well, since you didn't point that out as a problem at this juncture in the case, before the trial actually starts, you can't really point to that specific one. But yeah, it does seem to be the case that Ripple's attorneys are writing in a materially different manner than they had, and to this point, I want to see more of that. I would love to see more of that. With these little baby back brioches back in their place, little asshats hanging out in an asshat factory. Then there was this from Sherry V, responded to Jeremy Hogan's tweet and wrote, "If the judge does approve the addition to Dr. Metz's report, I would imagine Ripple would need to reach out to at least one of the 3 experts they'd hired from Compass Lexicon. Doubtfully, Marai or Fischel, the 2 of the experts, would be cheap in writing up a newer report, assuming that's an option." Jeremy Hogan wrote, "It is an option, just not one I think the judge should allow, but she may make the SEC pay for it. Also, not what should happen in my opinion." Yeah, so it seems to be the opinion of the attorneys within the XRP community that the most reasonable thing here moving forward would just be to not allow Dr. Metz's supplemental report because it's outside the rules of the court. That's what seems reasonable here. Now here's attorney Fred Rispoli, member of the XRP community, and here's what he had to say about this. The fair ruling would be to exclude the late filed report, considering SEC filed it 2 hours from the deadline. My prediction is Judge Netburn allows it, but accelerates the timeline and makes SEC pay for everything related to it, probably $100,000. Anything else is a loss for Ripple. And I know that might sound outrageous, but that's because the cost for this lawsuit is outrageous, completely. It's millions and probably tens of millions of dollars. And I kid you not. You can think about even the library case. Jeremy Kauffman, he publicly cited that they're already almost at $2 million. In their case, it's not at the same scope. Not to state that it's not as consequential or important, but it's not the same scope in terms of monetary claims against it and exhaustive research, because I'll just say this, my understanding at least is there's way more to consider and way more documents to go through in the Ripple case. So again, not to diminish the library case at all. I think it's of high consequence, and there's a reason I've been covering it on this channel for sure. But think about attorney's fees to put all these papers together. Like sometimes a single document, I've heard estimates, I can't remember if it was from Hogan or Deaton or somebody else within the XRP community, but like, yeah, some of these documents, the time spent, all this, like a single document could be 10 grand. How many documents have there been? How many more would have to be created? How many more reports from these experts that Ripple had already previously paid to come to the conclusion that Dr. Metz's methodology was fundamentally flawed? So it starts to add up really quick, unfortunately. So that's what Fred had to say. And then there was this from Bill, member of the XRP community. He's another attorney, and he wrote, I am still feeling uneasy about a favorable outcome on the motion to oppose the new Dr. Metz report. It would be unfair if Ripple lost the motion, and I am not saying it will happen, but this is why it may happen. Number one, Ripple's lawyers concede on point 3 that the new report of Dr. Metz is important. Its subject matter is important and was one of the 3 matters Judge Torres specifically referred to in allowing the fair notice defense noting. That Ripple states that XRP's price bears no relation to Ripple's activity. So they're saying, of course, the argument is fundamental to Ripple's fair notice defense. It's crucial, so might be allowed anyway. Point 2. Ripple reminds the court of SEC's previous delays and that it should not be rewarded for a further delay in breach of the rules. It seeks to outweigh the importance of the report by the unfair prejudice it will cause to the defendants if it is allowed. Number 3. This prejudice is expressed in terms of further delay and its impact on Ripple's business and causing it to use further resources. Number 4. As to delay, especially in terms of stifling Ripple's business, this argument has been made before by Ripple to oppose a motion of the SEC or prevent delay without success. Yeah, so we have seen this before. And I'll acknowledge that, certainly.
So enjoy your day, everybody. I'm always here for you. Leave any comments or questions below, and be sure to subscribe. But thanks, everybody. I really appreciate you. Enjoy your day, and I always have your back. So thanks so much, everybody.